What is discrimination? When is it unlawful? The client tells you their story. Something about it just doesn't feel or seem fair. They've been treated unequally or unfavourably or disadvantaged based on who they are or a characteristic about them. You might have a client who doesn't realise that what's happened to them is unlawful and it's unlawful discrimination. Or your client might think that that situation was incredibly unfair and discriminatory, but then that situation is actually not covered by discrimination law. Perhaps it's not connected to a protected attribute or a ground, or it's not in an area of public life that is protected at law. You should also be aware that there might be exemptions that apply, that in effect actually permit the behaviour and aren't covered at law. So even though it's unfair, it's actually not unlawful for your client. The discrimination might be direct or it might be indirect, and it might be quite subtle sometimes. And this distinction is often reflected in the statutes and the complaint process. Although it's not always clearly stated, discrimination law is underpinned by principles of equity, fairness, and the rule of law. It has its basis in international human rights law, for example, the International Covenant on Civil and Political Rights, 1966, and more specifically in federal law. The power of the Commonwealth to legislate in relation to discrimination comes from the external affairs power in the Constitution. This training guide will consider a range of different issues in discrimination law. It will consider types of complaints based on grounds or protected attributes. It will consider areas of public life such as employment, housing and education. It will also consider making a complaint in various jurisdictions, in particular WA and at a Commonwealth level, and it will consider appeal avenues. We've also included additional practice points to help you as a practitioner navigate this space. The following is an overview of the WA legal framework. Anti-discrimination law seeks to eliminate discrimination based on particular grounds or attributes. It is unlawful for individuals to be treated unfavourably when compared to others in a similar or the same situation. It's unlawful to discriminate on a range of grounds known as protected characteristics. And it is also unlawful to harass a person sexually, racially, or due to a disability. And harassment can occur alongside and in conjunction with, connected to, unlawful discrimination, but it might not be based on discrimination. In WA, the objectives of the Equal Opportunity Act 1984 clearly state that the Act seeks to eliminate, so far as is possible, discrimination against persons on the grounds of sex, marital status, pregnancy, family responsibility or family status, sexual orientation, race, religious or political conviction, impairment, age, publication of relevant details on the Fines Enforcement Register, and in certain cases, gender history. The WA Act also seeks to eliminate sexual and racial harassment in the workplace, in education institutions, and related to accommodation. A further goal of the Act is to promote equality between men and women. You should be aware as a practitioner of the Equal Opportunity Regulations 1986, which sets out in Schedule 1, Form 1, the complaint form that must be used when lodging a WA complaint. A complaint may be based on one or more grounds under the Act. In WA, you may also need to consider other various legislation such as the Disability Services Act 1993, the Lesbian and Gay Law Reform Act 2002, and the Gender Reassignment Act 2000. The following is an overview of Commonwealth statutory anti-discrimination law. The Commonwealth system is similar to state law and is comprised of the Racial Discrimination Act 1975, which makes it unlawful to discriminate against a person on the grounds of race, colour, descent, national or ethnic origin. There's also the Disability Discrimination Act 1992, which makes it unlawful to discriminate against a person on the grounds of disability. The Age Discrimination Act 2004 provides protections which makes it unlawful to discriminate on the basis of age. Further, and finally, out of the 4 pieces of federal legislation, there is the Sex Discrimination Act 1984, which makes it unlawful to discriminate based on sex and in some circumstances in relation to sexual harassment. You should also be aware of other key pieces of federal legislation, such as the Australian Human Rights Commission Act 1986, the Fair Work Act 2009, and the Fair Work Registered Organisations Act 2009. These can also be relevant depending on the context in relation to federal discrimination complaints. More recently, there's also the Racial Hatred Act 1995 and the Workplace Gender Equality Act of 2012 that you may need to consider depending on the facts and context of your case. Note that there can be relatively limited jurisdiction in federal law, and this is due to some of the constitutional restrictions, and you might need to consider whether a federal claim actually exists in relation to your client. For instance, in the Federal Sex Discrimination Act, it applies to discrimination and sexual harassment in connection with employment of Commonwealth employees or acts done within a territory, and discrimination in banking, insurance, and by foreign corporations, trading or financial corporations formed under the Corporations Act. However, outside of some of those contexts, the federal legislation may not cover your client. You may also need to consider in quite a lot of detail the intersection between federal discrimination law and employment law, particularly in relation to the Fair Work Act and employment-like settings. Organisations and businesses have a new positive duty to eliminate, as far as possible, discrimination on the grounds of sex, sexual harassment or sex-based harassment in connection with work and hostile workplaces on the grounds of sex and related acts of victimisation. This obligation is contained within the Sex Discrimination Act, and it extends to sole traders, those who are self-employed, and small, medium and large businesses, as well as government.